The importance of estate planning cannot be emphasized enough, but the value goes well beyond a simple will. Now, Terry Wheeler goes beyond the basics today to explain what you should know and how to protect your loved ones. I'm Patrice Sikora. Terry, let's start at the beginning. And what exactly is estate planning?
Well, hello, Patrice. Nice to talk with you again. Estate planning is really a broad area, but we always want to start just right at the beginning. So I'm going to I know this is our financial podcast, but I'm going to be wearing my attorney hat. We're going to go into some specifics. But for this particular podcast, we're going to be featuring California law. So it's important to know that if you're in a different state, because some states are community property, some are not. But the basic issues we're going to talk about are going to be very similar throughout the states. So first of all, what is estate planning? Well, you begin by looking at wills and trusts. So a lot of people don't realize that if you don't do your plan at all, then the state of California or whatever state you're in, they have a plan for you in what's called the probate code. And I often ask people when we're teaching, how many people think the probate code is going to do what you would want it to do? Oh. And most people say, no, they're not going to do what I want to do. Right. Well, they're actually trying to do what you want to do. So take California as an example. If you've been married for 30 years and you pass away, most of your assets are probably community property. Probate code says community property goes to your spouse. And overwhelmingly, that's what people do at the first death, is take care of their spouse. Now, let's say you have a child from a prior marriage. You have separate property. You get married. You've been married for a number of years, but you have separate and community property. And now you pass away. Well, California doesn't know. Did you want money going to your children first or to your spouse? So they just have to guess, and they create a rule that's one size fits all, and they give some to each. So probate isn't evil by its nature, meaning they are trying to do what you would want to do, but they don't know you. And you haven't done your planning. So they're just going to give you a one size fits all. So the plan itself is not what you should be afraid of. It's the probate process that you really need to avoid.
Okay.
So probate in California can last 18 months to 2 years for a simple estate, and you are overpaying your attorneys dramatically by statute. So probate is avoided by doing a revocable trust. So a will is instructions to the probate court as to how to administer your estate. A trust makes everything private, and you avoid the court system if you do it right. So we're going to talk primarily today about trusts and what they can do for you.
Now, you just mentioned something about probate and being private. Many people say, oh, I want to avoid probate at all costs. Is it that bad? I mean, it didn't sound like it's too bad. If you have your will, what's the big deal?
Well, it takes 18 months to 2 years, even for the simplest estate. So that's pretty bad to have your assets tied up and your spouse and children not able to get to them. If you have let's say you have $1 million estate, gross estate, meaning that's before you subtract your debt. But let's say you owe $700,000 on your home. That's a $300,000 net estate, but probate fees are based on the entire million. So the average probate fees are around 3%. So that'd be a $30,000 fee to administer $300,000 of equity. That's 10% of your estate gone to the attorneys and the personal representatives, whoever your helpers are.
And this is all public? This is all public?
It's all, court system is all public. All your assets, everything you own down to your personal items are all laid out in the court, and people can prospect you and find what you have, and then it gives them information that maybe they're nefarious and their intentions aren't good. So we really don't do will-based planning in California, hardly at all. You do primarily trust-based planning. Okay. So that should be the focus, even for the simplest of estates, is you can do a type of trust that we call a probate avoidance trust, which it can be very simple and straightforward, but at least it keeps you out of the court system.
Got it.
So we're going to hit on today what is a simple trust, but then we're going to spend a lot of time on what do we mean by comprehensive planning, meaning what all can a trust really do for you if you plan well. And that's what most of our clients do, is they want to build in a number of protections that go beyond the easy part, which the easy part is avoid probate. It's not hard to do. You just have to be proactive. So the tax planning, basic tax planning, and avoiding probate are standard. They're very easy to do. You just have to have a plan in place. And then we go into other protections. So that's the fun part of estate planning.
All right. Now you were mentioning revocable trust. What is that versus an irrevocable trust?
So a revocable trust means you can change anything as long as you're alive and well and competent. So if you make decisions today, as your kids grow older, things will change. As they get married, things will change, and you can update and change things along the way. So we look at estate planning as 3 steps. So the first step is create a comprehensive plan by what we call a counseling-oriented attorney. And we're going to be talking about what we mean by counseling. Second step is update and maintain your trust. Well, updating and maintaining your trust is an important step, but it doesn't have to be expensive. Once everything is done, it's in a Word document. It's not hard to pull things up, make a few changes, and press print again. So updating can be inexpensive. Sometimes attorneys will act like there's all this work that goes into it and it's so hard, and it's really not. But it's very important that you update, because lost opportunity costs can be the biggest expense in your estate if you're not updating correctly. And then the third is administering the estate after a disability or death. And if things are done well, this can all be done privately. It can be done at a fraction of the cost of probate, and it can be very efficient from a tax standpoint. And from a family protection standpoint, it can be extremely powerful.
Okay. So you wanted to talk about the create a comprehensive plan?
Yeah. So when we talk about simple planning versus comprehensive planning, a simple trust can be designed to say, look, my wife and I have a trust. If I pass away, it goes to her. If she passes away, it goes to me. And then we're going to give it out to the kids, either in outright or 3 stages. Now, we used to review trusts, and I can't tell you how many of the trusts that sometimes firms charged a lot of money for, that's all they did, is what I just described. And ironically, if you look at the legal forms, if you just were to pull up a law book and pull up a living trust, the forms said exactly that. And all these attorneys were doing is filling in the blanks, using search and replace and cut and paste. And they were doing what I would consider, it's not really a garbage trust. It's just designed to avoid probate, and that's it. So why spend a few $1,000s for something that simple? If you get a good basic trust, you're going to have some more bells and whistles. But comprehensive planning is saying, let's build this to do what you really need for your family. So we build in a variety of protections. So let's hit on them kind of one by one. So I'm just going to kind of walk the listeners through the phases of a trust. So you start by while you're alive and well. Now, while you're alive and well, the trust is you. It's revocable. You can change things, just like now in your life. You can change whatever you want to do, give assets away. You can make good investment decisions, bad investment decisions, completely up to you. The key while you're alive and well is to make sure your assets coordinate with your plan. So it's what we call funding. So you got to make sure the assets are titled right. So some assets will be titled in the name of the trust. Other assets will have a beneficiary designation. Maybe they go through the trust after the first or second death. And other assets will go around the trust altogether for tax reasons. So funding is the way you coordinate your assets to your trust, and it should be intentional based on how you design the trust. So getting the prep in place is what you do while you're alive and well. And then you run your life the way you always have. It's just your home will say your name as trustee of your trust instead of your name as an individual. So it's very easy while you're alive and well. So a trust isn't really doing much for you while you're alive and well. You're just preparing for the what ifs. Mm-hmm. Now, the first big what if is, what if a disability were to occur? And by that, we're talking about mental incompetency. Now, it could be temporary because you're in a terrible car accident and you're unconscious for an extended period of time, or in a coma, or it could be more permanent because you have Alzheimer's and you've permanently lost your competency. Now, when that happens, you have to go through what we refer to as a living probate, which is where you're going through guardianship or conservatorship type hearings. And somebody is now managing your life, and they're reporting back to the court regularly for the rest of your life. That is avoided through proper trust planning because you have a successor trustee. So this is a person that will take over management of your affairs, and they will follow your instructions as to how you want to be cared for in disability. So we can give instructions like, I want to be cared for in my home, but maybe I don't want my kids to be the caregivers. I want to rely primarily on professional caregivers because that preserves my dignity more. And it also allows me to not be a burden on my kids. And a lot of families and parents feel this way, but kids overwhelmingly think you want them to be your caregivers. But parents overwhelmingly don't want their kids as caregivers. So there's no right or wrong answer. It's what is best for you. So we lay out a plan. So we do this with both the legal documents and the legal provisions to give your helpers the power to make both medical and financial decisions during this time. But then we also supplement it with some detailed medical and disability letters of instruction. And these are just giving the kids or whoever your helpers are a little insight into how do you want to be cared for during this phase of your life. So those family instructions are not a legal issue. It's communicating your desires to the kids so that the legal empowerment, meaning the power you gave them to make decisions, can be used wisely the way you would want it to be used. Does that make sense?
Absolutely. Absolutely. I've been through this with my dad, and I know he did not want us taking care of him, but we did. My sister, my brother, and and I know he was extremely uncomfortable, but
Yeah,
that's what we
it's
have.
hard.
Yeah.
Well, and financially, a lot of families have no choice but to do that. Meaning it can be very expensive for long-term care if you don't have proper insurance and planning in place. Or if you would have loved to have had it, but you just couldn't afford it. So now families are providing the care. The hardest thing during this phase of life for couples is the first spouse that goes in and they need care. They can bankrupt an estate very easily, and the surviving spouse might have another 10, 15, 20 years to live. So it's not usually the person getting the care that is hurt. It's usually the loved ones you leave behind if you haven't adequately prepared financially. So that's something we do hit on in the estate plan, but the estate plan itself isn't doing the financial protections, but we have to coordinate your long-term care to your plan if you have it.
Got it.
So that's an important step. So disability, there's a lot more you can do, but it's all about family planning. The next phase is what are we going to do to provide extra protections beyond just avoiding probate and some basic tax planning. And this is where, when we're teaching, we introduce our attendees to a number of characters. And these characters all represent planning opportunities. So the first one that we introduce them to is a woman named Elaine. Now, we kind of jokingly say Elaine is your husband's next wife. So if you pass away, she comes in and she quickly looks at your decorations and wallpaper or whatever you have around and wants to change things. The kids are not hers, so she doesn't really see the need to save the money. She wants to travel and spend it all. And she might have kids of her own. So if the money ends up going to her, years may go by before she passes and your kids may be disinherited altogether. So for Elaine, what we're talking about is remarriage or bloodline protection. So all joking aside, Elaine can be a wonderful lady. So in our family, our Elaine, so to speak, was a woman by the name of Helen. And my grandfather was married over 50 years. I don't think he quite hit the 55-year mark when my grandmother passed away. He was remarried within 2 years, which is normal. That's statistically, with men especially, about 80% of them get remarried.
We know they need someone to take care of them. Come on.
They need help. Exactly. So for him, Helen was our Elaine, but Helen was an amazing, wonderful woman who made my grandfather's last years very enjoyable. She was there for him. She had lost her husband, so it was nothing nefarious, but she was a much younger lady. And by younger, he was probably about 80 and she was probably about 70 or so. And they knew each other in life, and they both had lost their spouses, and they became friends and then ultimately got married, all within 2 years. He left everything to Helen. Now, we didn't care. This isn't really a bad story in our family, but it is an example of how, if you don't have remarriage protection, it breaks down. Helen lived well over a decade beyond my grandfather. And when she passed away, which unfortunately was just recently in the last 2 years, everything went to her daughters. So I can tell you without hesitation, my grandmother would have wanted everything to go to my grandfather, and he would have wanted it taken care of. And by the
Right.
way, my grandparents worked with one of the biggest firms in Stockton to do their estate plan. And this firm sold them a fill in the blank trust.
Oh,
So they ultimately, everything went to my grandfather, and that's what my grandmother would have wanted. But my grandmother would have wanted it to go to her three girls when my grandfather passed, or at least after Helen passed, not to have them be disinherited. So when we talk about protections and remarriage and bloodline protections, this story plays out over and over and over.
sure.
We usually have 1 to 5 cases a year walk in where the kids are saying, is there anything we can do? And these are not from our clients, because our clients have addressed this, but these are people that there's nothing you can do really. You can sue for blood money, but you're going to lose. So it's just a matter of, will they settle and give you a little bit? But if they give the money to that new spouse, it's up to them what they do. You have no protection.
Hmm.
So in estate planning, proper comprehensive plans, we put protections in place. Now, let's take Helen as an example here. My grandfather definitely wanted to care for her. He loved her to death. We all loved her to death. She was a wonderful woman. Nothing negative to say about her at all. Uh, he would have wanted to care for her. So you had proper planning, we could have had provisions in their trust that says you can take care of your new spouse. They can live in the house rent free. Maybe even the expenses are all paid for. Maybe they even get a check of $5,000 a month or whatever you wanted for a budget for them to help them. But then when they pass away, we can design it in an irrevocable trust that the money then goes to the kids, and she would have no ability to redirect it to her kids. So that would be an example of remarriage protection. Another example would be to say at the second death, half of the estate. I mean, if I'm the first to pass away, maybe my half of the estate is locked in where it goes to the kids immediately after the second death, and we can't even redirect it. That's a decision for each client to make. So we walk through the options and then we build in protection so that we have remarriage or bloodline protection.
All right.
So that's the
And
first one.
if the well, the worst, let's say, happens, as you said, there's no recourse whatsoever for the kids.
Not really. I mean, you can try to sue, but their planning said it goes to this person and their wishes are followed. So you have no right as a child to the inheritance.
Okay.
If they give it to somebody else, then you're disinherited. So that's not typically the intent. I mean, my grandparents didn't probably intend to disinherit their three girls, but that is the way it worked out.
Mm-hmm.
And it's human nature, because Helen lived, and it might have even been almost 15 years beyond my grandfather. She lived a long time. She was in her late 90s. She considered that money hers. It had been hers for so long. She didn't probably even give it a thought that this money should be going back to the three girls. So it's just one of those unfortunate things when you don't do proper planning that happens a lot. So
Right.
remarriage or bloodline protection, most of our clients want to build that in. It's just a matter of how strong do we want it. Okay, so let's introduce you to the next character and the next type of protection. Now, this one, we usually put up a kind of a fun picture of your new son-in-law. So your new son-in-law, we have a picture of somebody that they're all tattooed up and they've got rings everywhere. And we describe them as somebody who loves following their favorite band around the country. They like some of these formerly illegal substances that are now legal in a lot of states. And they love the fact that they have rich in-laws. And they spend a little too much time being a kid versus being a good husband to your daughter. So the key here, sorry about that. So the key here is, in California, in most states, inheritance is separate property. So that means that it belongs to your kids. And if you go through a divorce, it's their assets. The problem is, as soon as you commingle the assets, meaning you put your paycheck into the same investment account that you have the inheritance in, as soon as it's commingled, it's presumed to be 50-50 community property. And now this individual is getting half of the inheritance if a divorce occurs.
Whoa.
Now, the creep could be the guy in the suit and tie that is taking business trips with his secretary and may appear to be upstanding, but he may be the creep. Or you may love your son-in-law or daughter-in-law, but do you want them to get half if the marriage doesn't work? So divorce protection is something that we don't leave up to chance. We build in protections each step of the way. It's invisible. It doesn't have to be discussed with their new spouse like a prenuptial or postnuptial would. And it's stronger than a post or prenuptial. And it's set up in a way that if they're married 50, 55 years like my grandparents, it doesn't hurt them at all. In fact, it's going to help them with something we call yellow school bus protection in a moment. So it's great protection, and it makes sure that the hard-earned money that you've worked your life to accumulate goes to those you desire, and it doesn't get split in half if a marriage doesn't work. So divorce protection is key. I kind of describe this as protection for the kids, but we can actually build it in for the surviving spouse also, in case they get remarried and it doesn't work out.
All right.
So divorce protection is a good one.
Yellow bus protection. What is that?
Okay. Yellow school bus protection. So what we're talking about there is asset protection. And I describe a story where we have a surviving spouse. Now, when we're telling stories, we always let the husbands pass away first in our examples. So she's out on a rainy day and she's approaching a four-way intersection. She's not texting. She's not screwing around with the radio. She's not doing anything wrong, but her shoes are a little bit wet. As she approaches the four-way intersection, a yellow school bus is coming by. She reaches for the brake and her foot slips and hits the gas a little and punches into the school bus. Now, unfortunately, I've seen this accident actually occur in reality, play out on the news. So it was really odd. We're telling this make-believe story, and then we were watching the news one day, and it literally happened. The school bus careens over into a creek. Severe disabilities or deaths occur. Now, in California, that's going to be about 2 to 2.5 million per individual. Now, if you think about your auto insurance, most people have about 300,000 to 500,000 of liability coverage for their auto insurance. We try to get all of our clients to buy an umbrella policy. So you might have 1 to 3 million of additional protection. And these are policies that are very cheap. You hardly ever need them. But if this yellow school bus accident occurs, it's your first line of defense. Now, I think we're paying about $400 or $500 a year for, I think we're at 3 million of protection. So it's not that expensive, but it's very important protection. So that's your first layer of defense. But in this type of accident, they're still going to take your assets. They're going to get the umbrella. They're going to get your underlying policies, and they're going to get your assets other than what can be protected in bankruptcy. In a trust, we can build in protection for that surviving spouse. So half of the estate that came from your husband that passed away is protected from litigation. And it cannot be taken when an accident like this occurs. Now, in reality, it's far more than half because we also will have IRAs, 401ks, and other things that are outside of the trust. Those are allocated to the survivor's half the way we do this, and those are protected largely in most states from bankruptcy also. So in California, it's about $1 million, and then the judge has discretion, do they protect it or not? 401ks are unlimited. So if this happens to somebody, you set up a little Amway business and you roll it back into a 401k and it's completely protected. So there's a lot we can do to protect usually about 80 to 90% of the assets for the surviving spouse. So building in yellow school bus protection is not something you can do after the fact. You have to build it in before something happens. But that protection isn't just for the surviving spouse. We can protect up to 100% of the estate for each of the children. So they get protective trusts so that if they're ever sued, money can't be taken. If they ever go through a divorce, money can't be taken. And then we also protect them from themselves. So before we get to protecting them from themselves, to wrap up the yellow school bus protection, this is something that is not needed by hardly anybody. But if something happens, that terrible car accident occurs, or if your child is a doctor in private practice, so they're subject to litigation a lot, or in construction, these are protections that are invaluable and they cannot give themselves the same level of protection. So it's something that you have to give them. They can't give to themselves.
All right.
So the next protection is protecting the kids from themselves. And this is 100% pure family planning. And we look at this as phases of life. So I have 5 children. 3 of them are triplets. They're 14 years old now. I'm going to see probably a little bit of everything with the kids, meaning strengths and weaknesses. Of course, I think they're all wonderful kids and we're going to have no problems at all. But with kids, sometimes you've got your guardianship period, first of all. And during guardianship, if you are having your guardian be the trustee of the assets, there are plenty of cases where this guardian all of a sudden has reasons why they've got to drive the $100,000 car. They have to have a bigger house. They have to have all these things that are now in their name, and they're dwindling down the estate that is supposed to go to the kids. Now that is the biggest fear commonly with people, but the opposite is actually probably even more common. And that is where you choose a guardian because you trust these people. They're the people that you know are going to take good care of your kids, and they do, but they do it so much to the degree that it's to the detriment of their own retirement. Meaning they end up spending all of their money to raise your kids. You've got plenty of money set aside for them. You've planned well, but they feel bad ever touching that money. So they're spending their money to raise the kids, and they love your kids, and it's all a good thing, but you want to protect them too. So we'll often build in budgets, almost like child support. So those guardians might be getting $2,000 a month for each kid to raise them until they're 18, or whatever budget you think is appropriate, covering daycare and things of that nature, healthcare expenses. If your kids are doing private school, then you can cover that also. So we build it to protect the guardians from overspending and from underspending so that the kids are cared for the way they should be. We also leave the guardians detailed guardianship letters of instructions. One of the most extensive was a family that one of the families, I forget if their faith was Catholic, but it was not Mormon, and their guardians were Mormon. And they had two very different faiths, and they were both very religious families. They outlined exactly how they wanted their kids to be raised from a spiritual standpoint. And the family that was going to be the guardians, they agreed they would do all of this. And it was really neat because they worked very well together. But if you're Mormon, you don't necessarily know all the rituals and everything for Catholic or for any of the other faiths. So they outlined it in very good detail so that if something happened, you had some input as to how your kids were being raised. Is it important to have strong work ethic or spirituality or involvement in the community or private schools versus public schools? So we all come from different backgrounds and have our opinions as to how the kids should be raised. So we want to leave a little bit of that roadmap for your guardians.
That's something I never even thought of, to be honest.
Yeah, and hopefully you outlive it and you don't need it. Yeah. So most of our planning, our goal is that we're wasting our time because we don't want to use it, of course. But eventually we all use it. So that's kind of the guardianship period. But then you think about as they're getting into the college years. So I have one in college now, one's a senior this year in high school. So we're entering those college years, and knock on wood, hopefully we're going to live through it all and we're going to plan it. But in our estate plan, we've outlined what happens. So for us, as an example, if we pass away right now, they don't have an option to just live off of the trust assets. If they go to school, we're providing for it. But if they're going to go to work and they're going to be flipping burgers for now, I forget what the minimum wage is in California, but I think it's going up from 15 to 20 bucks an hour if you're flipping burgers. But we give them a 25% earned income match. So they would get, instead of 20 an hour, they'll get 25, but they're going to have to work. We're not letting them live off the trust because work ethic is something very important to us. And the way we were raised, that was one of the most valuable qualities our parents passed down to us. So we want them to struggle a little bit through their 20s, learn the value of the dollar, learn that this money doesn't come easy. A lot of hard work, sweat, and tears went into saving this. But if you just inherit the money, they statistically spend it in less than 3 years. So we need to give them some wisdom along with the money. So we structure it.
The first generation earns it, the second generation uses it, and the third generation fritters it away, loses it.
Yeah, rarely goes to the third generation. Yeah. So when you're talking about big wealth with planning, that could happen, but it's like the lottery syndrome, where it's amazing how many lottery winners they are separated from their money within 3 years of receiving it.
Amazing.
So it's one of those things that, not everybody's the statistic, of course, but you want to protect them because it's so easy to protect them. Let's just do that. So the 20s for us, we do earned income matching. Some people will just do a certain amount of a budget that they can get to. And then at some point you decide when are you going to give them more and more access. But we phase in access to a protective trust that has that divorce protection, the yellow school bus protection built in. And the ironic thing is these protections, a lot of our clients have older children. I mean, they've already past the guardianship phase and their children are 30 or 40 or even 50 years old. And we have these interesting conversations where we ask them, well, how much have they saved for their retirement? Because you think giving people money, if they're 50 years old, you would think they would make good decisions. And for here, my dad passed away years ago, and I loved him to death, but he was not good at holding on to a dollar. So he was in a situation where he had retired on a shoestring, like a lot of Americans. He basically had a little bit of money saved, not much, and he had Social Security. He retired early because he had to go out on disability. So he had back problems from the Vietnam War era. He initially kind of retired early, and then we figured out he could qualify for disability. So he did that, but it takes months to do that. And the way it works is by the time you get qualified, if you applied 8 months earlier, you get those 8 months all at once.
Oh
So
my.
for him, he got a check that was in the neighborhood of $40,000 for back pay that was owed to him. And at his house, the mail used to come around noon. By 8 o'clock that evening, he's calling me to come over to check out his new pickup truck, which
Oh
was a
no.
$50,000 pickup truck. So not only did he spend all the money, which he would owe some
He
taxes and other
spent
things on that too,
more.
he had to take a loan out for the rest. And it was a nice truck. It was a very nice
I
truck.
hope it was a great truck.
And he was so proud of it. And it was like, I mean, I'm glad he was able to experience that because he ended up not living that much longer. But ultimately, just because you're in your 50s doesn't mean you know how to hold on to a dollar. If you didn't learn delayed gratification by then, it's not going to happen overnight just because you inherited money.
What color was the
So
truck? Was it red?
it was orange. It was,
Orange.
yeah. It was one of these Dodge, like, I forget what it was called, but it had a tail at the end. Like it looked like a race truck. I mean, it was,
Oh gosh.
my nephew still has it in Tennessee and it's probably 20 years old now, but it's a powerful truck. Like you can get yourself in a lot of trouble driving that thing. It's got lots of power, but he loved it. And he was always a truck guy. And that was, I'm glad he got to enjoy that, but it wasn't necessarily a good financial decision. So you want to structure this for even older kids, slow them down. Maybe you say, look, you can only take out, like, our trust ends with what we call a total return strategy. And what this means is, let's say somebody inherited $1 million, and the total return strategy could say, look, you can take out 4 or 5 or 6% a year, whatever that January 1 balance is. So let's say it's 5%. You get $50,000 a year, plus you can live in any real estate that's owned by the trust, or you can do a 0% mortgage so you can own the real estate in your name, because there's tax reasons to do some of that. That gives them more than enough access to slow them down. And if they're buying real estate, they're getting the use out of it, but they're not spending down the assets. That's something that's going to protect them forever. So putting in strategies like that can help really make your wealth that you're leaving be powerful for the kids. So that's one of the big protections. And then the last protection I want to talk about is taxes.
Yeah.
So taxes are usually when I was trained as an estate planning attorney, when I was in my early to mid 20s, the focus was showing people how bad estate taxes were. And back then, estate taxes were bad, and you could have a $700,000 estate and be subject to estate taxes. So nowadays, it's very different. It takes, for a couple, you have to have over 23 million before you're subject to estate taxes. So for most people, we're focused on minimizing income taxes and capital gain taxes. So when you pass away, one rule is what's called a step up in basis rule. And what this means is if you have a rental property, let's say you bought for 200,000 and now it's worth 800,000, when the first spouse passes away, if it's community property, all of the gains are forgiven. So you could sell the property the next day and you don't pay any taxes. When the second spouse passes away, if this is done right, you get another step up in basis before it goes to the kids. So we are doing planning to optimize that. Now, this is important because anybody who has an estate plan that's, say, about 5 years older, they typically have what's called an A-B trust. I mean, the estate splits in half because that's how you used to do tax planning. Well, if you do that, you're losing the step up in basis on the second death if you put real estate there. So it's outdated planning. People haven't updated their trust. They're one, doing a far more expensive trust administration, and they're not tax efficient. So there are tricks if we run into that trust, how to fix it in trust administration, but they're all clunky and you have to live with them for years. So it's easier just to do a simple amendment and fix it now. So we maximize step up in basis, and then we also want to maximize income tax savings. Now, income tax savings is a whole world of options depending on your assets. So let's take the single biggest one and just cover that. So the biggest asset we see, or there's two really, your home. So that's for step up in basis, and then your IRAs. So your retirement accounts. So we have a lot of physician clients, and it's very common that they have several $1,000,000 in their retirement accounts. They have very strong pensions, and then they oftentimes have their home paid off by the time they retire. So physicians tend to be very good at delayed gratification, so they're very financially sound. Now, many of those individuals, they have such strong pensions, they're so good at delayed gratification, they can't make themselves spend more money in retirement. So this $2, $3, $4, or $5 million retirement account is just going to grow, and it's going to their kids. Now, their kids, if they're doing well and even in the mid brackets, if you have two kids and you have a $3 million retirement account, that's $1.5 million each, and that's when they retire, but they typically live for another 20 years. So that 3 million is probably at least 6 million, probably 12, 15 million. Let's just say it's 3 million per child by the time they pass away. The tax rules say you have to take it out within 10 years. So mom or dad passes away, it goes to you as the child. You have 10 years to take it out. So if you spread it out over 10 years in order to keep your marginal brackets down, you still, if you're in the mid brackets, you're still going to lose about 40% of that money, because California, we have a lot of state taxes too. So your $3 million, you're going to pay $1.2 million roughly in taxes. So that $3 million inheritance is really $1.8 million on an after-tax basis. And the only thing that matters is what we get after paying taxes. So who cares what the number was before taxes are paid? So we do tax planning there. Now, you can do that in different ways. So one, you can make them take it out in 10 installments to at least minimize the impact. But what we'll often do there is we'll run it through a charitable strategy that allows the money to go through a charitable type of trust, and you pay no taxes. So the entire 3 million is now there to create wealth for your kids for the rest of their lives. Now, we often ask people if they have any idea how many people have pensions these days. And the numbers, when I started practice over 30 years ago, it was about 3 out of 4 people had pensions. The numbers today, it's about 1 in 16. So 401ks came about, and corporate America shifted responsibility to Americans to save in their 401ks for their retirement, and they did away with their pensions. Right. So this strategy creates a pension for your kids. So that 3 million, if you're going to, let's say we set it up to where it's paid out at 7% a year. That means $210,000 of income go to your kids each and every year for the rest of their life if they're able to earn 7%. So the way this works is you get 7% of the January 1 balance. So if they manage the money poorly and it crashes, their check goes down. If they manage it well and it goes up, their check goes up, just like if you own the property in an investment account. In today's environment, it takes roughly 18 years to where you're in the profit area. And what I mean by that is when the kids inherit this $3 million IRA, if they didn't do the charitable strategy and instead took the 10 installments and they saved it and invested it the same way you could, I mean, they optimized the savings, which we know almost never happens. They spend the 10 years of payments and then they don't get any more payments. And they're used to living pretty good by then, but the money stops. But if they were to do that, they're only going to be able to match the charitable trust for up to 18 years. So if you're an older parent like me, we were 40 when some of our kids were born. They've got a 40 plus year life expectancy beyond ours. They'll get about 22 years of profit. So the profit is massive in this strategy, and it can be 7 figures routinely for clients. So it's something that we do with tax planning in order to really stretch out or delay the tax bill over the lives of the kids. And the taxes never have to be paid but they're deferred all the way until the kids pass away. Now, you're going to feel like you're disinheriting the grandchildren, which most of our clients love their grandchildren. So you're not really disinheriting them. Your kids have so much more wealth that can go to the kids. You're fine. But we have advanced strategies. We're going to do a podcast on this subject. In fact, I think it's the next one in line.
Excellent.
And we're going to go through this in detail, and we're going to show you how to defer it for multiple generations. So it can be a powerful strategy. So taxes are a big one. We do address it. We do eliminate estate taxes, of course, and we do maximize your step up in basis so that ultimately your plan works for you. So we often tell people come in where we need to check that box and get our estate planning done. But if you just check the box and you don't do these protections, remarriage protection, bloodline protection, divorce protection, if you don't build all that in, your plan is not tested until it's too late.
Right.
And once you realize you have a shortfall and you don't have remarriage protection, it's too late. You've just disinherited your kids. So you got to be proactive in this area. And it's not hard to do, but it's very important to get it done.
So it sounds to me like the only time it's too late to do this is when you're dead.
Yeah, you don't need to do planning. Just make sure you sign your documents the day before you die and you're okay. So the challenge. Yeah. And we tell people like this charitable strategy. The problem is, what if they change the laws on you? I said, your risk in this strategy is you're wasting your money to get the planning done. But the strategy for most kids, if they're adults, we can put in a 20-year minimum payout. So even if they die early, the money goes to the grandkids. So there really is no risk there other than they change the law and you have to change your planning again. And that's always a risk in estate and tax planning is the, bureaucrats change the rules all the time on us. Then we have to adjust. So that's why updating is so important.
Well, Terry, how can someone talk to you? There's a lot to talk over to find out what they need to do, what they should be doing, and strategies. So many great strategies here. How can they?
Sure. So for this, because again, I'm kind of wearing the legal hat today. I think the best way to reach out to us here is to go to our law firm website, which is www.strategicwealthlegal.com. And then, of course, you can just call the office, 916-325-0130. And we've got contact forms and everything on the website. If you just have questions, just submit them and we'll be glad to help you. But it's something, if you're not in our state, we can connect you to a colleague in another state, perhaps. But we are licensed to practice law here in California. So we only offer planning for California. But we'd be glad to point you in the right direction and answer any questions.
All right, fantastic. So listeners, as you've seen or heard, some estate planning can go a long way to secure a future for those you care about and yourself too. In other words, follow this podcast for more information and share with others. And thanks for being with us.
Yes, thank you, Patrice.
Thank you.